Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now we introduce our guest and our host, Alan Schnorman.
Welcome to Lawline. The recent proposal of Dr. David Axelrod, the State Health Commissioner, for an overhaul of the New York State medical malpractice system to a no-fault plan has sparked heated debate on both sides of the issue. This plan would abolish the rights of seriously injured patients to take legal action against the negligent doctors or hospitals. The proposal comes on the heels of the release of the $3 million Harvard study by the New York State Department of Health, which estimated in 1984 36,000 people were negligently cared for in the state. Today we'll look at the no-fault medical plan and the Harvard study and their impact on the healthcare system in New York State. Our guests are Philip Damashek, President-elect of the New York State Trial Lawyers Association, and Peter Millock, General Counsel of the New York State Department of Health. Hello, Phil. Hello, Peter.
Hi.
Peter, tell us, what is this plan, the proposed no-fault plan?
Well, the plan is really just that. It's not yet put in formal legislation, but it is a proposal that is based on the Harvard study, as you suggest, and it is really for a review and evaluation of the current tort system to try to get a system that will actually serve as more of a deterrent and compensate people more fairly for injuries.
But Peter, what does it do? I mean,
well, at the present, of course, it doesn't do anything, but it is, the idea would be to set up some system which would allow for an administrative determination as opposed to a court determination of the amount of the need, actually, of the injured party, the medical need, the lost wages, and other things, and compensate that person quickly for those losses, rather than going through a total litigated system as we have now.
Phil, what's your comment on the proposed plan?
Well, I'm somewhat surprised in that the Commissioner of Health is charged with regulating the quality of care delivered to the people of the state. This report, and we believe that it significantly understates the problem, certainly shows that there's a crisis in the quality of care which is being provided to people in the state of New York. 7,000 people a year being killed because of malpractice in hospitals certainly isn't something that either the Commissioner or the people of the state of New York should accept. And the answer certainly can't be a system which helps the doctors and does nothing for the patients.
Well, do you have a proposal to meet this, the Harvard study, or do you feel the present situation complies with it?
Well, unfortunately, in the year that the Harvard study was done, the Commissioner only was able to discipline 16 doctors for negligence and incompetence, when we know that there were tens of thousands of people, according to the study, who were negligently injured in hospitals, not in doctors' offices, in hospitals. And we believe that the problem has to be solved not by the Commissioner of Health any longer, because the Commissioner has failed. The problem has to be solved by educating people and make them better medical consumers to avoid the doctors who are doing this.
Peter, let's take a step back. Now, the state commissioned this study, did it not?
Yes, it did.
And what did you hope to achieve by commissioning the study?
Well, at the time when the study was commissioned in the mid-'80s, there were a lot of reports of a crisis in the medical malpractice system, and the legislature passed legislation that would reform the tort system in some significant ways. It wasn't the overhaul that we're proposing, but there were some significant changes. And part of that proposal, part of those changes, was to commission or to authorize the health department to commission a study of the underlying system. Too often in the past, and this debate about malpractice has gone on for 15 years, we have had a debate that's been characterized by rhetoric and emotion on both sides of the issue, and the legislature and the commissioner felt it was important that there be some facts to fuel the debate.
And Phil, what did the Harvard study actually come out with? What did it show?
They claimed that in the year that they studied, 1984, that there were something between 3,000 and 38 claims involving medical malpractice.
3,000 and
3,000 and 3,800, they claim, were generated by this huge amount of malpractice that was being committed. and then argued that the lawyers are not doing their job, and that's what the problem is. First, if you recall, they criticized us, saying that we were suing too much and we were creating a medical malpractice crisis in the courts. Now we hear that we haven't been doing our job well enough and we're not suing them enough. The reality, however, is that the numbers that the Harvard study speaks of, between 3,000 and 3,800 claims, is not an accurate number at all. For instance, in 1986, when the court system began tracking the number of malpractice cases that actually were being brought, they found that there were over 14,000 in 1986. That does not jibe in any way with the Harvard studiers who tell us that there were only 3,000 in 1984. Absolutely not. That's a mistake. And I can only hope that that mistake has not been transposed onto the number of people who've been killed by doctor negligence.
And Peter, the department, the health department, what did you get from the Harvard study that you're taking and using?
Well, the Harvard study is a very long document with a lot of facts and findings on a whole host of issues. And I think that it makes many relevant findings, or findings relevant to a lot of public policy questions. One question is certainly the viability of the current tort system and how well it provides compensation and a deterrent factor to poor care. The study also addresses where poor care occurs and what sort of practice is likely to cause poor care and what hospitals provide better or worse care. And all that sort of information, I think, is crucial to the development of public policy in the healthcare area. So there are lots of things in the Harvard study that are very useful, irrespective of the specific relation to tort.
Peter, how do you respond to that part which Phil brought out, that from all these, I mean, there were thousands of people who were victims of negligence. I think the study said 7,000 actually were killed by medical negligence or died as a result of medical negligence, and yet Phil brought out a point of only 16 doctors being disciplined.
Well, first to correct the facts in terms of what the Harvard study found. The Harvard study focused on a sample of about 30,000 records taken from 50-odd hospitals in the state. And they concluded, the Harvard study concluded, that about 1% of the discharges represented in that group of 30,000 were victims of negligent care. They then transposed or applied that number, that 1%, to all the discharges that occurred in the state in 1984 and concluded that there were many injuries and some deaths caused by malpractice.
7,000 of them, Peter.
That's right. No, I'm not disputing that number, but that number is not an actual finding of 7,000 deaths. It's a transposition.
It's a statistical number.
It's a statistical. It's extrapolation from a sample to the whole number. And I think that that's a startling number, and to us very surprising and a cause of great concern.
What's surprising to the lawyers, though, is that the attention of the commissioner is now being turned to the lawyers rather than the doctors who are committing this malpractice.
Well, I don't think that that's a fair statement at all. I think the commissioner has several responses to the startling facts. One response is an overhaul of the tort system. A second response is an improvement of all those systems that now are in place, in addition to the tort system, which are aimed at deterring poor care. And the third thing, which you mentioned in passing, was a flood of new information that's coming out, doctor-specific and hospital-specific, that will be made available to patients and prospective patients about the care they're about to receive. That actually is the most startling development. It doesn't relate specifically to the Harvard study, but it is the response, or one of the three responses that we have
Peter,
to those facts.
Are you saying that the commissioner would support making public the practitioners' national data bank information to the people of the state of New York?
Well, I'm not sure about whether that specific information would be made public.
But that's the information that's available and would help people.
Let's just find out. This data bank, is that where a physician, if he's negligent and the information regarding that negligence goes into that data bank?
Claims, suspensions, disciplinary actions, all of that is fed into this national data bank.
Is that now a secret, not open to the public?
I'm not sure what their access is. It's just really been created on a formal basis by federal law. We've just been participating in preliminary work to get access and to make submissions to the bank. We have no problem getting access to that bank, but we're talking about something that's much more elaborate and sophisticated than the kinds of things that are in that bank. That bank just shows what physicians have been have been the subject of misconduct actions in New York and other states. What we're looking for is much more elaborate information about the quality of care provided by individual physicians, the quality of care provided by individual hospitals and other providers, and making that information available to everybody in a meaningful way. In my view, that is going to revolutionize the tort system, whether no fault is put in place or not. It will revolutionize informed consent and that whole and that doctrine and the usefulness of informed consent in med mal actions. It's a dynamic change which is about to happen.
Well, we have to take a break now, but I would like you to think about the question how this plan is going to improve medical care to the patients. This is Alan Schnorman. You're watching Lawline. Stay with us.
There's a reason people whisper when they tell you a rumor. It's because 9 times out of 10, it's not true. Take all the rumors about AIDS. People are saying you can catch AIDS from a mosquito bite or in swimming pools. The fact is there isn't a single case of AIDS on record caused by casual contact. It's up to you. You can believe the rumors or you can get the facts.
Rumors are spreading faster than AIDS. Call your local Red Cross for the facts.
The party's over. All over one for the road. All over for the 25,000 Americans who die each year as the result of drivers who drink. Drivers who don't realize how little it takes to turn the average social drinker into a tragedy. So please, take this advice from this station and the members of the New York State Bar Association. When in doubt, don't start out.
And now a word from the American Lung Association. Your lungs are an incredible piece of machinery, but your lungs are also incredibly delicate. Diseases of the lung are among the most frequent causes of suffering, disability, and death in the United States. Lung cancer is now the #1 cancer killer in America among both men and women. Chronic bronchitis and emphysema are marked by chronic obstruction to the airflow. Among chronic diseases, asthma is the leading cause of school absenteeism. Yes, TB is still with us. In the past year, over 22,000 Americans have contracted TB. Lung trouble can come from the air you breathe at work, but thanks to the American Lung Association, you can breathe a little easier. They're working to fight all this lung disease. Your lungs are a miracle. Take care of your lungs. They're only human. And if my lungs weren't in great shape, I couldn't have said all this. The American Lung Association. The Christmas seal people.
Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today we're talking about the proposed no-fault medical malpractice insurance plan and the Harvard study. Our guests are Phil Damashek, President-elect of the New York State Trial Lawyers Association, and Peter Millock, General Counsel of the New York State Department of Health. Peter, right before the break, I asked you, how is this proposed plan going to help the patients receive better quality care?
Well, I think the two aims of any system are deterrence and compensation. The Harvard study showed in some ambiguous way that the current system does not have a big deterrent impact on bad care. It's not doing a job in preventing bad care. When you look at the big numbers of bad care in 1984, that said something about the effectiveness of the tort system.
Peter, all that says is that doctors, in spite of the tort system, go on hurting and maiming people negligently. It's not an indictment of the tort system, it's an indictment of the quality of care which is being delivered to the people of the state of New York. And I really think that it's part of the health department's job to turn its attention to kind of reduce that significantly.
Well,
can you respond to that?
Certainly. We've turned our attention to that long ago. You cited the figure for disciplinary actions in '84. Since that time, we've doubled the staff of people who are investigating and prosecuting bad physicians. We've tripled the number of cases. We have, by all accounts, one of the top state systems for disciplining physicians, and we think more should be done.
Even the medical society doesn't like your system.
Well, they're not supposed to like it. It's supposed to be directed.
They say it doesn't work, and everybody seems to agree with it. It's not working.
We agree that it's an elaborate system. That was not our fault, however. That's the fault of a legislative creation, which is too elaborate. And we've made a proposal to improve that program. We hope that the trial lawyers support that proposal.
Peter, let me see if I understand it. You're saying that the present system is not a sufficient deterrent against medical negligence, and that the proposed plan, which the department proposal, will go further towards that goal?
Well, I think that any system has to be a deterrent to bad care. Otherwise, it's not working. The current system, there are many systems that are directed at poor care. The tort system, the insurance system, the various monitoring programs run by government, peer review by hospitals and physicians themselves. All of those things together make up the current system. We propose a system which we think in the no-fault area will provide better compensation to people who are harmed by bad care. We don't see, because the Harvard study didn't find any particular deterrent effect from the tort system today, but we recognize that if there is any deterrent effect, that has to be made up by changes in other areas.
Phil, let me ask you this. As a trial lawyer, do you find that victims know when they've been malpracticed against?
No, of course not. The only time they even suspect it is when somebody on staff comes to them and says, you know, you really ought to speak to a lawyer. They hear what the doctors want them to hear.
Well,
we've done everything we could.
How often does that happen, that a co-medical provider will say that to a patient, in your experience?
Fortunately for some of these people, more often than you would expect, and that's great. There are people who are part of the system who understand this conspiracy of silence that exists in medicine today, and they're willing to make these quiet suggestions.
Peter, is a healthcare worker required to do that?
Certain healthcare workers, particularly physicians, and the facilities themselves are required to report misconduct, which can be negligence, to the state health department. That doesn't often happen. Very few of our complaints come from
They're
physicians.
also supposed to report incidents, Peter. Incidents of adverse events. That doesn't happen.
Well, that's
the
not
Harvard
fair.
study certainly shows it doesn't
Well,
happen.
the Harvard study was covering a year when the incident reporting system didn't exist.
But the very next year, when the department's study did go into effect, they only showed something like 8,000 or 9,000 adverse events,
Well, but that's
when
not-
Harvard showed 120-some-odd thousand adverse events.
No,
That's not
no,
working.
that-
You
you're
know,
not- well, Phil,
even the
you're not-
commissioner says that the doctors are not reporting these things.
Well, we're confusing apples and oranges. There's an incident reporting system in hospitals which went into effect in 1985 after the Harvard study, year of study.
Right.
And it is now generating 10,000 complaints or 10,000 incident reports a year. Almost 9,000 of those relate to poor care as opposed to things like fires and outside
Peter, does the
events. That's a
department-
lot of reports.
does the
But it's not nearly what Harvard found.
Well, it's less. It's significantly less than what Harvard
So,
found. But it's
so
not.
they're
it's-
lying to you. So they're hiding
lying?
it from you.
Oh, that's
the
absolutely-
doctors and
I'm not-
hospitals are hiding it from you.
Well, some hospitals
but
are
you turn to
underreporting.
lawyers and blame us.
We're not blaming.
let's
We're
get
blaming
control here,
everybody.
gentlemen.
We're blaming government, doctors, and lawyers. Nobody's doing the job. The tort system is not
Oh, we're
working.
doing the job.
Doctors are not providing good enough care, and
Let's-
government, admittedly, is not providing enough monitoring.
Let's just quiet it down for a second. Phil, how do you feel the present tort system is doing the job?
Okay, Harvard found that one of the things which is most on doctors' minds is the fear that we represent, that they will be called to task for making mistakes and for doing things that they know they shouldn't. Let me tell you, this is a serious problem. A former president of the American Medical Association indicated that, in his opinion, almost 10% of the doctors practicing medicine were doing so either drug or alcohol impaired. What are they blaming that on us? What do the tort lawyers have to do with that?
Peter, how do you feel the present system is not achieving that?
Well, I think the current system for disciplining physicians or dealing with impaired physicians is not sufficient. We've increased our production, our productivity by a tremendous amount since 1984. It's still not enough, but nothing that we can do. And we can triple the number of prosecutors. We can quadruple the number of investigators. But we're never going to identify all the doctors in advance who are going to provide poor care in the future. There has to be a system for dealing with the care as it occurs, with negligence as it occurs. And the current system doesn't do it. The one salient fact that I think does raise questions about the tort system today, the one fact we haven't mentioned, is that only 1 of 8 people who are harmed file a claim. Now, Phil may question whether the numbers are a little off or more off, and if his numbers are correct, then it's 1 in 6 or 1 in 7.
Why do you feel that's true?
Well, I don't know why that's true. I think part of the reason is that people don't know that they've been the victims of poor care. I would agree with Phil in that area. I think lawyers don't take cases that they don't think will be remunerative. I mean, the old people who are likely, actually most likely to be harmed, are also the people who are likely to less likely to win awards or get awards in the tort system. So maybe the law office serves as a triage or serves as a screen for good cases.
What happened, Peter, was the medical profession lobbied for some changes in the laws, which they succeeded in getting. Now, before you can start a lawsuit, you have to get a doctor to indicate that in his or her opinion, there is merit for bringing that lawsuit. And you know that they just don't cooperate, even when they're sure that there's been malpractice.
Well, I mean, you're an experienced tort lawyer, and I would defer to your judgment on the med-mal system, but within the disciplinary system, where we also rely on medical advice and medical opinion, we have no problem in getting doctors to give us opinions about other doctors. I think that's an old story.
We have to take a break now, but I'd like you to consider this question. If somebody loses a leg due to medical negligence, under your proposed plan, will they be compensated for their pain and suffering? You're watching Lawline. This is Alan Schnorman, your host. Stay with us.
My father taught me to steal and to pitch. Today I struck out 7 and stole home. I think Dad would have been proud. Coach was. He said he wished Dad had taken as good care of himself as he did of me and Billy. Billy won't talk about it, and Mom can't stop crying. I don't know what it's like to have a heart attack, except I can see it hurts. It hurts bad.
You can help prevent heart disease. We can tell you how.
My father, Gordon McRae, was one of the biggest stars in musicals. He was also an alcoholic. When I was little, I thought I could stop my dad from drinking. But only the alcoholic can do that. And finally, my father got help and stayed sober the last 7 years of his life. I was so proud of him. Alcoholism is treatable and preventable. Be alert to signs that you might need help, especially if you're the child of an alcoholic. For information, call the National Council on Alcoholism, 1-800-NCA-CALL.
Talking computers. High-speed Braille printers. New technology helping blind and visually impaired people participate fully in today's computer age.
Counter moving the top of page.
For more information about putting high technology to work for blind people, write American Foundation for the Blind, National Technology Center, Box 111, New York, New York, 10011. The American Foundation for the Blind.
Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today we're discussing the proposed no-fault medical malpractice system by the State Department of Health. Our guests are Phil Damashek, President-elect of the New York State Trial Lawyers Association, and Peter Millock, General Counsel of the New York State Department of Health. Peter, right before the break, I had asked you that question. If someone loses a leg due to medical negligence, under your proposed plan, will they be compensated for the pain and suffering they've endured and will endure in the future?
Well, our plan doesn't address pain and suffering. We haven't decided whether it should or should not include pain and suffering. There's no reason that it can't, although that obviously increases the cost of the system. What our system would provide would be some sort of administrative proceeding whereby the person would appear, would show what their medical losses would be, what their income losses would be, medical expenses, and that would be quickly compensated. That's the goal of the system. Under the current system, those people who do sue, the 1 of 8 who do sue, wait years and years for their compensation, particularly if anything goes to trial. So what we're aiming at is a quick resolution without dealing with the issue of fault.
But Peter, wouldn't that mean if a person is a low-wage earner, he will receive less money than somebody who's a high-wage earner, although he has the same exact injury?
Well, I think that's true under the current system of tort relief now. I mean, one's income is considered in determining lost wages.
But the leveling factor would be pain and suffering. Someone who is a highly paid executive doesn't become entitled under our system to more money than someone who is working as a laborer. If they suffer, they get paid under the system if their pain has been caused by someone else's fault. Now, what you said here before, Peter, is not really accurate. People, first of all, it's not going to be fast because first you have to establish that your injury was related to the medical care that was provided.
Proximate cause.
Proximate cause, which is a can of worms which lawyers struggle with right now under the current system. They will struggle with under this system. The only problem is the claimants won't be able to find lawyers to do that struggling because there won't be anything in issue for the lawyers. You're talking about people who will get nickels and dimes and have to fight for those nickels and dimes, and that doesn't make sense.
Well, in addition
to that, Kirk Johnson, the General Counsel of the American Medical Association, said that your no-fault system would be overwhelmingly cost prohibitive, and on the second ground is against it, is because people should be responsible for their acts.
Phil, I'd like you to respond to what Peter just said. He just said, well, right now they're getting nothing.
No, they're not. First of all, Their numbers, which talk about 3,000 to 3,800 claims a year, are absolutely absurd. The Office of Court
Claims of
Administration of malpractice, that's what he's talking about. He says that very few people who are injured by malpractice actually sue. Now, I think that there are a lot of people who aren't represented in claims for malpractice, who are the victims of malpractice, but we do a much better job than they want to give us credit for. They're talking about 4,000, 3,800. We know that in 1986, when they started keeping records, there were over 14,000 claims.
Peter, isn't it a fact that actually medical malpractice claims now are less today than they were a year or two ago?
I think they've leveled off.
And what about the plan? You had originally commissioned the Harvard plan because of what you had termed a medical malpractice crisis. Well, what did that show? Did it show that the tort system actually created the medical malpractice crisis, or something different?
Well, I think that it's a complex issue. I don't think that there's one cause of anything. Obviously, the root of the problem is poor care being provided by physicians, and that's medical malpractice. So in a sense, that's part of the crisis. Another part of the crisis is certainly in the insurance system and the way insurance companies calculate the premiums that physicians have to pay and what they do with that money. Another part of the crisis is certainly what effect those things have, what the existence of other monitoring programs and how effective or ineffective they are, and of course the impact of high premiums, not just on physicians' income, but on entry to physician specialties, on physicians leaving needed areas of care. Those are all part of the crisis. It's not just one thing.
Phil, it seems that we agree that at least the Harvard study showed that many of the patients here in the state of New York are getting poor care. At least it said that. Well, how would you improve that care, Phil?
I think that the solution to this is got to be three-pronged. Number one, the commissioner has to evolve a method of moving forward with regard to the doctors and hospitals who are identified as problems. They know that in the Harvard study there were a disparity sometimes as great as tenfold between the malpractice in one hospital as opposed to another. That means there's a problem if a hospital is committing 10 times more malpractice than another hospital.
Peter, you have 1 moment to respond.
We agree on that prong. I think that it's important to improve the system for regulating hospitals. A lot has been done since 1984. More can be done. Some of it's going to take money.
Phil, in summation?
In addition, the public has to be educated to be able to shop appropriately for the right doctors and hospitals. Right now, if they want to buy a toaster oven, there's information for them. If you want to find the right doctor, the right hospital, they're out of luck.
And with that, Peter Moloch, General Counsel of the New York State Department of Insurance, Phil Damashek, President-elect of the New York State Trial Lawyers Association, thank you both for appearing on Lawline. And as always, this is Alan Schnorman, and thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney, author and lecturer, Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions or comments about this week's program, please write to Lawline, 27th floor, 63 Wall Street, New York, New York, 10005.